matter of CMJ Foundation and others versus State of Meghalaya and others, Supreme Court dismissed the appeal of appellants and held that the procedure prescribed under Section 14(1) of the Act for appointment of Chancellor was not duly followed. Consequently, the appointment of Chancellor of the CMJ University was rightly declared to be invalid and non-est in the eyes of law by the Division Bench of the High Court, and the judgment to this extent does not suffer from any infirmity. The following key issues were posed for consideration of the court in the instant appeals: whether the appointment of the Chancellor of CMJ University was made with due adherence to the procedure as mandated by law. The court held that there is no dispute that the CMJ University has been established and incorporated under the CMJ University Act 2009 enacted by the Meghalaya Legislative Assembly. It's an admitted position that the appointment of Chancellor of the University was never approved by the visitor, that is, the Governor of Meghalaya. The contention of the learned counsel for the appellant that the failure of the visitor to grant approval of appointment of Chancellor would lead to the deemed approval is totally misplaced and unsubstantiated by law. The second question was whether the dissolution order dated 31st March 2014 was passed with due adherence to the procedure provided under Section 48 of the CMJ University Act 2009 and in compliance of the directions issued by the court via order dated 13 September 2013 in SLP titled as CMJ Foundation and others versus State of Meghalaya and others. Under the framework of the Act, it is clearly mentioned that the appointment of Chancellor of CMJ University, the sponsor, is not the sole authority, and the visitor also plays a pivotal role. The visitor is not merely a titular head, and the appointment of any person as Chancellor by the sponsor would attain validity only upon the approval of the visitor. In the present case, it is an undisputed fact that the visitor's approval was never granted for the appointment of the Chancellor of the University. It is a settled legal proposition that if a statute provides for the approval of the higher authority, the order cannot be given effect to unless it is approved, and the same remains inconsequential and a dead letter in the eyes of law. A perusal of the matter on record makes it clear that two show cause notices, the first dated 12th November 2013 and a supplementary notice dated 24 January 2014, were issued by state to appellants pursuant to directions by the Supreme Court. In response, appellants submitted their reply to show cause notice on 25th November and to supplementary show cause notice. Thus, evidently, the proper opportunity to show cause and take necessary measures for rectification was extended to the appellants against the proposed action of dissolution. Before passing the dissolution order, the state government analyzed the explanation provided by the appellants and evaluated the supporting evidence. While recording the final determination, it was thoroughly and minutely adverted to the manifest irregularities and discrepancies portrayed in running and management of CMJ University, and the same was discarded with exhaustive reasons. The dissolution order had been passed with strict adherence to procedural requirements under Section 48 of Act and in compliance with directions by the court. Hence, the decision of the state government dissolving CMJ University was affirmed. Third question was whether the division bench of the High Court of Meghalaya was justified in remanding the matter to the learned single judge for reconsideration on merit while allowing the writ. The court said that we fully concur with the view taken by the division bench of the High Court in upholding the validity of the procedure followed by the state government and the dissolution order itself. The court was of the considered view that the remand to the single judge was entirely unjustified and unwarranted. The controversy in the case had been exhaustively examined and determined on merits by division bench, leaving no questions unresolved issues for redetermination by single judge. As such, there was no requirement for fresh consideration of the case on merits by the single judge. Applying the Wednesbury Principle, the court, in the case of the Union of India versus G. Ganayutham, held that to test the veracity and the validity of the executive action or administrative action taken in exercise of statutory powers, the court and the tribunals in our country can only go into the matter as a secondary reviewing court to find out if the executive or the administrator in their primary roles have arrived at a reasonable decision on the matter before them in light of Wednesbury and CCSU tests. The choice of the options available is for the authority. The court or the tribunal cannot substitute its view as to what is reasonable. Further, in case of Gohil, Vishwaraj, Hanubai and others versus State of Gujarat and others, it was held that judicial review lies against the decision-making process and not against the decision itself. Once the division bench had approved the procedure and adopted by the state in passing the dissolution order, the exercise of remand would be nothing short of an empty formality. Therefore, the order of remand was legally flawed and untenable. Thus, the court answered its questions that saying that the procedure prescribed under section 14(1) of the Act for appointment of chancellors was not duly followed by CMJ University, and consequently appointment of the chancellor of CMJ University was non-est and void ab initio. The dissolution order had been passed with strict adherence to procedural requirements outlined under section 48 of CMJ University Act 2009 and in compliance of direction issued by the court. The division bench of High Court was not justified in remanding the matter to the single judge for reconsideration on merits. The decision of the state government dated 31st March in dissolving the CMJ University was affirmed, and it was open for the state government to take appropriate measures pursuant to the affirmation of the decision to dissolve the CMJ University.